Good morning to all of you. Welcome to my Civil Procedure Code class. In this class, we are going to discuss what is a precept. Precept, no doubt, it is mentioned in section 46 of the CPC. Precept is a temporary relief, temporary attachment of property. The dictionary meaning of the word precept is to issue a command, to give a writ, or please remember, a general rule intended to regulate the behavior. This is the dictionary meaning of the precept. So, section 46 of the CPC, it says attachment can be made under precept. Please remember, in which it is only ad interim attachment or temporary attachment to help the DHR, because it may take time for the decree to go from this court to the other court, because a lot of formalities are there. So if the JDR comes to know that this property is likely to be attached by the court, normally he may try to dispose it off. He may transfer it to somebody. He may align it to somebody. He may cut and harvest the crop, and the entire property will be disappearing. So in such a case, before the regular procedures of the execution of the decree follows, so a temporary attachment will be given. It will be operative for 2 months at one time. Of course, the court can extend the same. This is the summary of the so-called precept, section 46. So, please remember, as per this section, the court which passed the decree at the first instance, please remember, maybe sumoto or on the application of the DHR, better on the application of the decree holder, normally they issue a precept to the court within whose jurisdiction the property of the JDR is located or is lying. And it will be attached for 2 months only. It is a temporary attachment. It is not a relief. Please remember, it is not regular attachment as per the execution process, only temporary attachment. So, what is the object behind it? You have to know. The object is, please remember, to prevent the alienation of the property of the JDR in the name of some other person, because it has to be attached, it has to come to the share of our DHR. Of course, this is not a new thing. Of course, we introduced this precept in the year 1908 by the CPC, but previously, please remember, in the famous case of Subodh Prasad Malik versus Lakshmiput Singh Dogapur or Devpur, Lakshmiput Singh Devpur, reported in 1914. The Judicial Committee supported the so-called precept because temporary relief will be there. So 1914 itself, the judgment was there. Of course, 1908, this has come into this thing, almost similar time. The first case, this is a famous case. This is, please remember, Subodha Prasad Malik versus Lakshmiput Singh Devgar. Right. So, please remember, once the precept is issued, the transferee court, they will proceed to attach the property. Of course, attaching the property should be done with due procedure. That means the notice should be given to another party and they can take their explanation. But anyway, it will be temporary relief. This much you have to know. The effective period is 2 months. After 2 months, we can't do anything. Of course, the court has got right to extend the period also. Right? So, please remember, to apply the doctrine of precept, please remember, the first condition should be the property should be located in another court premises. And the apprehension to the DHR should be there that this property may be alienated to somebody. It may be transferred to somebody. It may be cut and taken away. Under those circumstances proved, then only the precept will be given. Please remember. So to conclude, I want to tell you, the concept of precept, definitely it plays a vital role in facilitating the execution of the decree in favor of the DHR and against to GDR. And I once again caution you that this precept is not execution, it is not attachment, it is only temporary attachment. So please read section 46 and enrich your legal knowledge. Thank you.